This is Earl White, real estate attorney. This is a video about how to transfer real estate into a trust in New Jersey. Okay, the first step in transferring real estate into a trust is to consider and evaluate the reasons you are thinking about transferring real estate into a trust. The main purpose of a trust is to avoid the probate process. This is a public process. Obviously, people could object to it. It is a court hearing, people could object to it, and many people transfer to a trust to avoid this public process of probate, and it could be a headache too. The other reason you would want to put your property into a trust is you can evaluate and set forth the reasons and the ways that you want the property to be handled. So in a trust, you can obviously outline obligations of the trustee, administrators, whoever you want to help manage the property. So you can outline the responsibilities and treatment of the property before you pass away and also after you pass away. So you get a lot of control with the trust. Now, a trust is not always the greatest idea. Many people think that just putting a property into a trust is going to grant many protections from creditors. But that's not accurate. You cannot just put property into a trust and now the property is free from any creditors being able to put a claim on the property. This may work more with an irrevocable trust. But the downside of irrevocable trust is it is in fact irrevocable outside of special circumstances, and therefore you can't make a change if your family dynamics change, and you can't make a change if the law changes. So irrevocable trust is somewhat risky. If that's the avenue to get creditor protection, then that may very well not be worth it to go down that road. Step 2 of the process of transferring real estate into a trust is to create the trust itself. Once you've made the decision that you're going to create a trust, and now you actually have to create the trust itself. Trust is a very complicated, very long document. You should be consulting a trust and estates attorney to make sure what's being set up is appropriate. You don't want to download a form online. You want a competent, qualified local counsel in that state where the real estate is to be able to opine the trust that should be formed in the terms of it. When you're forming the trust, you also need to think through the mechanics. So think through who is going to be the trustee, what are all the assets that are going to be funded into the trust, obviously the real estate, what other assets, and what are the rules, regulations, processes are you going to outline in that trust. Once you've done that, you sign, notarize the trust, and now the trust has been completed. Step 3 of transferring real estate into a trust is to conduct a title search. Many people who own real estate do not believe it's an issue to look for open title problems. A title problem is a claim on the property from a third party. There's no claims or there's no concerns about liens on the property, but you really don't know for certain because there is fraud out there and there are lawsuits with prior owners maybe if you inherited the property. So it's important to run a title search to determine any outstanding liens on the property because you don't want to spend all this time and money and energy on putting the property into a trust when there's a title issue outstanding that could prevent any decision making in the future. How to get the title search? You have to contact a local title company. It's only a couple $100, $300 to run a title search. Contact local title company. They're going to search the public records, run name searches on all the prior owners and the current owners, and then give a report back to make sure there's no liens. As part of this process, you may also want to submit an Open Public Records Act request for similar reasons. Find out any open permits, any code violations, anything that's going to impact the value or quality of your ownership. You should find out before officially making the transfer to the trust. Step 4 of transferring real estate into a trust. You've decided you want to do the trust. You've run a title search. You've decided how to set up the trust. The trust has now been set up. Now you need to prepare the legal documents necessary to convey the property into the trust. Again, typically a real estate attorney would help with this process to make sure that the documents are prepared and executed correctly before they're submitted to the county. So what documents do you need? You need a deed. The deed is a document that conveys the ownership to the trust. This would state that you're a resident taxpayer or it was a principal residence of the prior owner, and there's other reasons. But the purpose of this form is that you do not have to pay an out-of-state 2% withholding on this transfer. So you have to have the get rep form necessary for recording. And then finally, you need an affidavit of consideration. An affidavit of consideration lays out what's the consideration for the transfer, right? So if it's just a trust, if you're just transferring straight to a trust, and there's no purchase price being handled here, there's no purchase price. If it's a sale, then yes, there'll be consideration. Consideration will be the sale price. If you're just doing a transfer from yourself directly into a trust, you're probably just doing it for $1. You're not going to make a payment directly to the trust. However, you should be aware that consideration is not just payment, but also if the person that you're transferring to, or the trust in this case, is absorbing an open mortgage, then that is also consideration, and there may be a realty transfer tax that be paid on that, which is also another important consideration that you should think about, is that is your lender, if there is an open mortgage, very more simple, but if you have an open mortgage, you may need to get special approval from the lender, or at least look at the relevant laws about how they apply to your trust, whether it could cause the lender to have a right to accelerate the due date of the mortgage by a transfer of ownership. There are federal exceptions that prevent that for trusts if the party that's transferring it is also the beneficiary of the trust, but again, consult with an attorney on this. Step 5 for transferring real estate into a trust: sign the conveyance documents and record them. So we mentioned deed, get rep 3, affidavit of consideration. Those documents need to be signed. Affidavit of consideration needs to be notarized. Deed needs to be notarized. Your notarization process, if you can go either to a local, like a notary public, or you can have the attorney, if they're handling, notarize it. There can be, like I said, it could be any notary or an attorney. Once the documents are signed and notarized, you would give them to your attorney, and then your attorney would handle the recording process with the county. Often, modern day, we'll submit it via e-recording, so we submit it online, or you could do it via paper mail or dropping it off. Once the county receives it, the county will give you feedback. They will say, these documents are okay to record. Otherwise, they may say, we would like a change in the documents, for example, a date or a word, or they might want a statute cited or regulation cited. So normally they'll convey that to your attorney. Attorney will make necessary changes. Once the attorney and the county agree on the changes, then the document will be submitted for recording. That recording takes about 30 days. And then we'll get the recorded deed back with all the stamps, book number, page number, instrument numbers. And then about 30 days from completion of that recording, the city will then update their tax assessor record to reflect the new owner. So don't freak out if you go to the county, if you go to your city and your attorney tells you, oh, it should be 30 days. There is a delay for the city to update it. First done with the county, then done with the city.